Yes, good morning, everyone. My name's Andrew Singer. I'm the head of the technology and construction team at King's Chambers, and I shall be chairing this session. So as far as the first couple of speakers are concerned, and then our third speaker, Kelly Pennifer, is going to take over chairing. Thank you all for coming, taking time to be on this webinar today. This is one of a number of webinars that we've held over the last 8 to 9 months. As you know, King's holds technology and construction seminars on a regular basis. This seminar focuses on construction rather than technology. Our next seminar in the new year is going to focus on technology. We've got 3 speakers for you today. Before I briefly introduce the 3 of them, can I just explain that we're going to have questions and answers, and we're going to try and do the questions and answers after each of the speakers. So if you have any questions, please use either the chat function or the Q&A function in the Zoom facility, and someone will monitor those and we'll ask 1 or 2. Each of the speakers is going to speak for about 15 minutes, and then we'll have about 5 minutes for questions before moving on. First speaker is Jonathan Ward. He's going to discuss assignments and novations, first from a historical perspective, and then with particular emphasis on a very recent decision of the Technology and Construction Court in a case called Energy Works. Our next speaker, Oliver McKenzie, is going to discuss delay, termination, suspension, and force majeure issues arising out of our dear new friend, COVID-19. And then Kelly Pennifer is going to speak about adjudication, liquidation, and injunctions by reference to the recent Supreme Court decision in Bresca. So without any further ado, I'll ask Jonathan to speak first. Thank you.
Thank you, Andrew. I'm just going to put up some slides. Which hopefully you can now see. Andrew, can you see the slides okay? Okay, great. So yes, I'm talking about assignment and novation in the construction context. These are 2 familiar concepts in the law of contract, and they are perhaps of particular significance in the construction field. They are no doubt familiar to anyone who has been dealing with certainly medium and large-sized construction projects and disputes. That's not to say they don't occasionally arise in smaller projects. The concepts of assignment and novation are to some extent similar in that they both involve the interposition of a third party, so a stranger to the original contract, assuming a contractual relationship with at least one of the original parties. But the concepts are different, fundamentally different, and they're not merely different applications of the same doctrine, as we'll see. There are some important distinctions to bear in mind. There are some traps for the unwary, and perhaps even traps for the wary sometimes. Some of the contexts where we will see assignment and novation or novation in the construction field are set out on this slide. In the case of a design and build project, it's often the case that the employer will have engaged professionals prior to the engagement of the contractor, and upon execution of the design and build contract, those professional appointments will be novated to the contractor. Another typical example is where the contractor goes into insolvency, and the employer then looks to take over subcontract or professional appointments. And equally, the purchaser of a property or development will sometimes look to take assignments of contractual rights against subcontractors or professionals. Some important differences. Usually when we talk about assignment, we talk about, or we mean the assignment of the benefit of the contract. For example, the right to be paid for services that have been rendered or are still being rendered. Less commonly, perhaps the right to have some work done under a contract may be assigned. It is possible to assign the burden of a contract, but that requires the consent of the other party. There's an example given in one of the cases, I forget which, but if a publisher contracts with an author to write a book, they may be somewhat disappointed if the author assigned the actual writing of the book to someone else. Obviously, it's different if we're talking about simply the assignment of the right to be paid having written the book. You can usually assign the benefit of a contract without consent, and that's a general proposition. But one of the traps we'll look at is that contracts may contain an express prohibition against assignment. And that is perhaps, in fact, the norm in standard form building contracts. As for novation, well, that does require consent, and it actually involves not merely the transfer of part of the original contract, but the termination of the original contract and its replacement with another contract between different parties. So that obviously requires agreement all round, and it requires consideration. But subject to that, the effect is that one of the original parties relinquishes both the benefit and the burden of the original contract, and a new party is interposed. So looking at assignment now in slightly more detail, this isn't a definitive summary, and there's a lot to be said about assignment, but just some matters that you might bear in mind. The first question is, does the contract prohibit assignment, or does it make it subject to consent? That's the subject of the decision in the Linden Gardens case, which went to the House of Lords. And the effect of that is that if there is a purported assignment without consent, it doesn't merely give rise to a right of damages by one of the original parties. It means that the assignment simply doesn't happen. It's of no effect. Another point arising out of the Linden Gardens decision is that a distinction may be drawn in some cases between accrued rights under the contract and future rights. So in other words, it may be possible to assign future performance, or the right to future performance under the contract, without assigning rights that have already accrued. But what that case makes clear is that if that's to happen, then very clear language must be used. So an example would be in terms of accrued rights, rights of action, causes of action in respect of existing defects, and future rights would be the right to have further work done, or perhaps the right to further payment in the future. So generally, a prohibition on assignment will be interpreted as prohibiting both accrued rights and future rights, or the right to future performance. That's the Linden Gardens decision, although clear words may indicate contrary intention. And the other point is that it doesn't matter whether consent could not have been reasonably withheld. And you may have seen that in some contracts, the way these clauses are phrased is to say assignment or no assignment without the express permission of the employer, such permission not to be unreasonably withheld. But if you go ahead and purport to assign without even asking for permission, even if there were no reasonable grounds to withhold it, the assignment is nevertheless of no effect. Novation, as we've noted, this isn't merely a special case of assignment, it's a different doctrine. An assignment of benefit and burden of a contract may have similar effects to a novation, but it is not a novation. Novation is a different species. Notably, the subject to equities rule does not apply to novation because we're talking about a new contract. So if the original contract was procured, for example, by misrepresentation, or was subject to a claim for rectification, those rights wouldn't be preserved. Those rights would be preserved against an assignee. So someone taking an assignment of the contract would nevertheless take the assignment subject to those rights and those equities. The same doesn't apply in the case of a novation. So the parties to a contract following a novation wouldn't have rights as regards misrepresentation, rectification, or whatever else which tainted the original contract, because as we've seen, novation involves the making of a new contract. What about pre-novation breaches of contract by the remaining party, and can the incoming party make a claim? That's actually quite a difficult question. There's an interesting case which I've put on the slide called Blythe and Blythe. The position isn't straightforward and it's outside the scope of this seminar, but if that point arises, then the Blythe case is a good starting point. So that brings us to the real subject of today's talk, which is the very recent case in the TCC of Energy Works and MW High-Tech projects. This case considered many of the interesting aspects of assignment and novation and explored the differences between them. So briefly, the facts. The project was the construction of a gas from waste power plant. EWHL was the employer. The main contractor was MW. The subcontractor was Autotech. The works were delayed and EWHL, the employer, terminated the main contract, alleging delays and defective work. There were provisions in both the main contract and the subcontract which enabled EWHL as the employer to take an assignment of the Autotech subcontract from MW, the main contractor. And that's actually what happened. Following the termination of the contract, MW, the contractor and main contractor, assigned the subcontract. And you'll note that subcontract on the slide is in speech marks for reasons which will become apparent, assigned the subcontract to the employer EWHL. EWHL then made a claim against MW, the main contractor, in respect of alleged delays and defects. And MW sought to pass on the liability by claiming against Autotech, the subcontractor, and was disappointed to be met with the defense that it couldn't sue the subcontractor because it had assigned the benefit of the subcontract to the employer. So the case, the authority that we're talking about was actually the trial of a preliminary issue or several preliminary issues. There were some questions about same damage under the Contribution Act, but for our purposes, the preliminary issue trial considered the following issues. Firstly, did MW, the main contractor, retain the benefit of rights against the subcontractor post-assignment? In other words, having assigned the subcontract to the employer, did it still have a cause of action against Autotech? And if not, did the assignment operate as an assignment of both benefit and burden and therefore amount to a novation? So the first question really, or what it boiled down to was what was assigned? What rights and obligations did the contractor, main contractor, owe, and what rights was it owed by the subcontractor post-assignment? As you might expect, the judge began by looking at the subcontract and the main contract and the notice of assignment, all of which referred to the subcontract. And assignment was prohibited under the subcontract, except in two cases. Those cases were, firstly, Autotech, the subcontractor, could assign the right to payments that are due. And secondly, MW, as main contractor, could assign, quote, the subcontract. And that term is perhaps what gave rise to some difficulties, because what the contractor MW sought to argue was that because it said assign the subcontract, what that meant was not merely the benefit of the subcontract, but the whole thing, the benefit and the burden. But as we know, you can't assign the benefit and burden of a contract without consent. So MW's argument was the words subcontract must mean benefit and burden and must indicate that such consent was agreed, pre-agreed in the contract, and therefore amounted to consent to, in effect, novation. They said that the commercial reality of the situation was that MW would never have agreed to assign its past and future rights under the subcontract, because that would leave it in the situation where it was facing claims by an employer that it couldn't pass on to the subcontractor. The problem that the contractor had was that it ran into some fairly weighty authority on these points, in particular Linden Gardens, which was a House of Lords case. Now, the point about assign the contract, in quotes, was considered expressly in that case. And what was said was that that was generally to be considered as shorthand for the benefit of the contract. Because as they said, every lawyer knows you can't assign the burden without consent. So a prohibition on assigning the contract must be taken to mean a prohibition on assigning the benefit of the contract. And that House of Lords case also dealt with the distinction between past and future rights. And it said that clear words must be used if these are to be treated separately. There weren't any clear words demanding that they be treated separately here, so the usual meaning was not displaced. So the judge in Energy Works, the decision here, decided that MW had assigned both past and future rights. In other words, it couldn't bring a contractual claim to pass along the employer's claim to the subcontractor. The judge recognized that the way the contract had been drafted exposed MW to a commercial risk of this type of scenario, but took the view that that was basically the contractor's problem, and the court wasn't going to step in to relieve it of a bad bargain. And you can see a quote from the authority on the slide. In support of its arguments, MW had raised some, what it said were difficult issues which would arise from the construction that the judge was adopting. And the judge dealt with those. Those issues covered, for example, who would be responsible for payments under the assigned subcontract. Could the employer instruct additional work, having been assigned the benefit of the subcontract? And the judge dealt with those. And it's, as you can see from the slide, paragraph 78 to 81 for a discussion of those issues, which are quite interesting in the way that the judge dealt with them. The other issue, the second preliminary issue, was whether the assignment actually amounted to a novation, because it assigned both the benefit and burden. As we've seen, the judge said that clear language had to be used if you were going to assign the burden as well as the benefit. Such clear language wasn't here. And in any event, even if the burden was assigned, that wouldn't amount to a novation. The judge emphasized the difference between the concepts, and perhaps unsurprisingly decided this issue on the basis that only the benefit had been assigned, and essentially said, if the parties say assignment, then they probably don't mean novation. So some final thoughts. The concepts of assignment and novation, they're familiar to all of us, I'm sure. They're perhaps deceptively simple. You have to be careful what you wish for. Now, I'm not a, I'm a disputes lawyer. I don't get involved in drafting suites of construction contracts, but it does occur to me that perhaps collateral warranties and duty of care deeds may have made for an acceptable contractual scheme for the employer here, and may have preserved better the contractor's position in this scenario. But the case shows that care must always be taken when considering agreeing to an assignment or novation, and when examining disputes where there have been changes in parties to the contracts. Thank you very much.
Thank you very much, Jonathan. I haven't received any questions in the chat function or in the Q&A function. So unless anyone wants to raise a metaphorical hand, I will hand over to Oliver. Thank you very much.
Hi, good morning. I'd like to speak to you today about, as Andrew described it, our friend COVID-19 and its impact in terms of delayed termination, suspension and force majeure in relation to construction contracts. And I want to consider the topic essentially from two angles. Obviously, the restrictions are likely to be with us for at least another 4 months yet. And we're obviously likely to see all of the impacts we've seen across the year, whether that is in terms of unavailability of labour, manpower, self-isolating, plant not being available due to unavailability at staff at plant hire companies, supply chain delays and all the rest. So in the first instance, I want to consider how things stand, whether under the major forms or under what one might describe as back of a cigarette packet contracts as they stand now. And secondly, I want to consider the impact of the crisis in terms of the future, because there's no getting away from quite how drastically the crisis has affected our society and economy as a whole. And it does seem to have established a new paradigm where one has to ask what will happen not only in relation to COVID-19, but when the next pandemic or crisis hits. And what I want to look at is a number of initiatives that have been going, mostly driven by the government, that address the future-proofing of contracts in relation to pandemics and other exceptional events. I said I would deal first with informal contracts because those are, of course, the most problematic. One is, of course, familiar with the typical informal house building contract with no provisions as to extensions of time, no agreed date for completion, or at least uncertain provisions in that regard, and no provisions dealing at all with the impact of force majeure, employer delays, or other exceptional events. Being at the junior end of chambers and being one who deals with rather more of these informal contracts as one might like, it's been my experience that in a significant number of cases, COVID has been advanced as repeatedly advanced as a delay for all manner of, as an excuse for all manner of purported and real delays. And of course, one of the problems, and we'll come on to this when we deal with future proofing, is the forensic difficulty of establishing a connection between purported delays resulting from an event such as a pandemic and the impact on the works. One need only think of the typical problems that might be caused by self-isolation, for example, particularly on an informal contract where, say, there won't be a program, much less a resource-loaded program, and it's then asserted that due to the self-isolation of certain members of the workforce or an entire team that had to be sent home, it was not possible to carry out work on a particular work front, and that has had impacts on the progress of the works. Given the lack of forensic clarity, it's very difficult to trace through those consequences into the impact on progress. And those difficulties are only compounded under a contract where matters are left informal. Now, of course, in circumstances where where the contractor is severely affected by pandemic delays under such an informal contract, that of course raises two questions. First, will the contractor be able, at least in substance, if not formally, will they be able to suspend performance of the works or embark upon significantly reduced performance of the works to reflect the impact of the crisis upon completion? And if there are significant delays resulting from that, and the employer is not satisfied that in fact coronavirus is the real cause for the delays, whether the employer is going to be able to terminate on account of those. Dealing with the matter of suspension first, it's well established, and the audience will be well familiar with the principle that it's simply not possible to suspend works on the grounds that they have become unduly onerous or even temporarily impossible for the contractor. And in this context, a lot will depend upon whether or not the contract specifies a fixed completion date and the impact that has in terms of the default allocation of risk as between the employer and the contractor. Because of course, if one does have an EOT provision, then the ultimate issue is whether the relevant events are captured on the true construction of the contract and to whom those responsibility for those events is allocated. But if we have the typical informal contract with no extension of time provision, but one which does specify a fixed completion date, which is not at all unusual in the low value house building end of the market, well then of course there is risk both for the contractor and the employer in that regard. From the contractor's point of view, he's at risk because he's undertaken to complete the works within that period of time, and he by default takes the risk of exceptional events that haven't been expressly allocated to the employer. So obviously, while that's bad news for the contractor, equally, of course, we shouldn't forget our old friend, the prevention principle, because of course, if there's any material employer act of prevention that delays the works, then time will be set at large. And of course, that has the effect of causing the fixed deadline for completion to fall away. And of course, therefore, when one is standing in the contractor's shoes, if one is hit by the pandemic, one doesn't have a right to an EOT and there is a fixed completion date, then obviously the contractor is going to have to be very much astute to find events which might reasonably argue to be an act of prevention in order to facilitate at least some form of negotiation with the employer. While it's true that at common law there's no right to suspend the works as such, we have a contract that does not specify a fixed completion date, then it may in fact be possible for the contractor, if not to suspend the works altogether, then at least to embark on some reduced form of performance to reflect the impact of the pandemic. And that is simply because where there is a reasonable time for performance, it's established by authority that varies to reflect the circumstances that exist as and when the contractor is required to perform, and they're not responsible for events which are outside of its control and for which it couldn't have reasonably accounted or for which it could not take steps to mitigate. Of course, that also cuts across the obligation that will be implied into your typical informal construction contract to proceed regularly and diligently with the works. But again, that effectively mirrors whatever has been agreed in terms of time. It's not an absolute standard. And again, the contractor would be able to justify reduced performance at site, if not a complete suspension of works, if indeed it is able to establish at least some impact resulting from the crisis. I do say at this point, and this applies across the board, whether under a formal or informal contract, that it is, of course, critical to document the impacts as best as possible. Given in particular the impact that the crisis has had in terms of labour, it probably makes sense to have some form of protocol established among the workforce at site, so that they know how to document, record, ensure that if they're not attending at site, that some form of daily record is completed to establish that they weren't able to attend because of the pandemic, and what the reason for that was. From the employer's perspective, I simply make the brief point that repudiatory delay in theory might be a ground for employer termination, but in practice, you have to show that the delay deprives the employer of substantially the benefit of the contract, and under an informal contract, that's likely to be relatively rare. I have done a slide about frustration here, but the point should be relatively straightforward, that the requirement to show that a supervening event strikes at the root of the contract will be an insuperable obstacle for either the employer or the contractor. Turning now to contracts which contain an express force majeure provision, I probably need not go into the definition of force majeure or the case law on that. It's well known to be an elusive concept, and one which we all know when we see it. And plainly, at least in principle, the pandemic is force majeure. That, however, is never going to be the end of the inquiry, because there's always an issue as to causation with force majeure clauses and exceptional event clauses, at least where they contain wording which requires some form of, or indicates that some form of causal link is required. That is clear from the classic maritime case, which I've referred to on the slide. Essentially, in the case of force majeure, much the same approach is taken as in cases of employer and concurrent delay. It is required to show on a but-for basis that the force majeure event did in fact have an impact, and therefore it's not simply possible for a contractor or indeed the employer simply to throw their hands up in the air and say, utter the words COVID-19. The impact does need to be documented and established. As regards the standard forms, we're all familiar with those. I simply make the point that it's important to bear in mind that not all of the standard forms deal with the impact of force majeure in the same way. In particular, the JCT form will allow the contractor an extension of time, but will not allow loss and expense. I've mentioned notice provisions here, but given the time, I'll just discuss future proofing, because as I said, the pandemic has set a new paradigm, and there are obviously questions that need to be dealt with at the contracting stage. Some of the audience at least will be familiar with the initiatives from the Cabinet Office to propose model deeds of variation for all of the standard forms. Those have included a so-called COVID relief payment for which a contractor can apply to alleviate non-payment, to alleviate cash flow issues. COVID-related hardship is also accounted for. There's a possibility of further monetary claims in respect of that. And there are also provisions in these model deeds which allow for the employer and contractor to agree changes to the payment schedule. There is, however, a quid pro quo with these to account for the obvious risks which I highlighted earlier, which is simply that the contractor could throw their hands up and contend that the delay for which they realistically are culpable is attributable to the pandemic, but because of that, and because of the forensic difficulties, each of the model deeds of variation contain transparency provisions which require the contract effectively to allow its position to be audited in terms of the delay. Also, because of the forensic difficulties in these model deeds of variation, COVID hardship is dealt with slightly differently from prolongation. Instead of there being an actual claim to the actual cost sustained, there's an entitlement to claim a certain amount of money to account for the hardship generally. And you'll also note that in the CLC best practice guidance, there's a sort of halfway house where there is an entitlement both to an extension of time and to money, but that is apportioned on a percentage basis. That may be something of a Heath Robinson approach, but it at least seeks to moderate the unfairness that might result to the employer if COVID were to be permitted simply to allow the contractor to make blanket claims to additional payment. So to conclude, obviously it's these are very interesting and challenging times, and it remains to be seen what the courts will do with the causation and force majeure issues that arise out of existing contracts. We won't really get any cases out of the first wave until probably next year, and obviously there are significant developments on the contracting front, and it's very much a case of watch this space with that.
Thank you very much, Oliver. You're not getting away quite so quickly, because yes, I'm glad to say there are a couple of questions I'm just going to format, and then there's a question that's come in about novation, which I'm going to ask Jonathan to deal with. But whilst Oliver's on, I'll just ask him one of the first questions. He could be thinking about that for a second, and then which is that time at large due to prevention by the employer. What do you think about the scenario where, for example, there's a house build, then there's delay to practical completion because utilities aren't being connected because the utility company has a huge backlog? Do you think that's employers' prevention, or is that out of their control, or something else?
Well, I mean, it depends. If the contract is completely informal, such that there's absolutely no provision for, if on its construction it says nothing else, nothing other than that, the contractor has to establish the utilities connection, then yes, on the application of the basic principles, yes, that risk event does lie with the contractor. If, on the other hand, and it will depend on precisely why it is that the connection can't be established. But if there is, yes, certainly, if there is some obligation of the employer which is required to perform to facilitate that connection, and for whatever reason the employer can't facilitate it, then it would be an employer risk event. But yes, in principle, it's the contractor that bears that risk. Okay.
You've also been asked to just repeat, please, if you may, why termination for repudiatory delay is difficult for an employer.
Well, that's relatively straightforward. Unless the contract contains provision to the contrary, a fixed completion date, it will not be that time is of the essence in relation to that. So it will be necessary to show that the failure to attain the completion date was such as to substantially deprive the employer of the benefits of the contract. Now, obviously, if there's a very, 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 very substantial delay in a construction contract, then yes, it may be arguable, but certainly in the Shorting and DGN case, that was treated as more a theoretical possibility than a real one.
Yeah, thank you. And just finally, it's been asked that as we are now in the middle of the pandemic, presumably relying on a force majeure clause, if you start work now, is going to be difficult.
Well, absolutely. Well, it's not if you start work. If you agree a contract now, yes, that's absolutely the case, because Whereas a year ago, we'd never have imagined that we'd be in this situation. The reality is it's now become, to use that horrible expression, the new normal. And it won't be possible, in my opinion, for contractors to say, well, I could never have anticipated this sort of risk on entering into a contract.
Thank you. And then just a quick question for Jonathan, which is that can you have a novation without it being in writing? In other words, by conduct, part of the three parties in question, or in other words, a sort of informal, non-written novation. Is that possible?
Yeah, I think there are two related questions there. Firstly, does a novation have to be in writing? And the general position is no, it doesn't, unless there's something in the original contract that says consent is required or it must be in writing. So you could have an unwritten agreement which constituted a novation. And I think the other question is whether you could infer such an agreement from conduct, so even if it wasn't expressly agreed otherwise than in writing. And again, yes, there are cases where novation by conduct has been recognized.
Thank you very much. I'm going to pass the baton now, in every sense, to Kelly, who's going to talk about the Bresco case and then deal with any further questions. I'm going to take my leave. Thank you all again for attending. I wish you all a jolly and careful Christmas, to borrow somebody else's latest expression, and hope to see you all properly in the new year.
Good morning, everyone. Obviously, I'm talking about the Bresco and Lonsdale case, and in particular, the interplay between adjudication and insolvency, which I think it's probably fair to say has been an issue which has arisen and had to be considered by the court in several different contexts for almost as long as the Housing Grants, Construction and Regeneration Act has been in force. And it's the nub of the problem, of course, is that on liquidation or bankruptcy, either way, on the insolvency commencing, pursuant to the insolvency rules, there is a mutual set-off of debts. So an account has to be taken of what's due from the company to the creditor to each other in respect of their mutual dealings. And one has to be set off against the other. And that final account therefore results in a final single sum due to one or other of the parties, dependent upon how the set-off works. Now, an addition to the problem is the decision, or that has been historically an addition to the problem, is the decision of the House of Lords in Stein against Blake. Now, that was actually a case which concerned an assignment or purported assignment post-liquidation of a claim without the cross-claim. So what was being assigned purportedly was one of the claims, competing claims, rather than the net balance. And the question the House of Lords had to consider there was whether or not that assignment was possible. And having considered in detail the rules on set-off, within all contexts, so equitable or indeed in the context of the insolvency rules, House of Lords found that the incident of the mutual set-off rule in insolvency was that the claims and the cross-claims merged and were extinguished to form a single claim, which was represented by the balance of the account. Thus, the assignment, or purported assignment in that case, of only part of that process, the claim, was ineffective. Now, against that very brief backdrop, the initial debate or context in which the interplay between adjudication and the insolvency set-off rules arose was when parties were trying to enforce an adjudication award in their favour, where the defendant was saying that it had an independent cross-claim, which of course, given the introduction of Section 111, it was unable to raise as a defence, but existed there as a separate cross-claim. Now, normally, absent insolvency, that's not an issue. It does become an issue if one or other of the parties is insolvent. And that dispute was really resolved a long time ago with decisions such as Boog against Dahl Jensen, and Wimbledon Construction Company against Vago. Generally, as a general rule of thumb, Summary judgment would either be refused in those circumstances as a matter of discretion, there being some other good reason why the matters should go off trial, or there will be summary judgment granted, but subject to a stay of execution, although those rules are not invariable. That's the Wimbledon case. If, for example, there are circumstances which suggest that the party seeking the stay has essentially caused the claimant company's financial difficulties. More recently, particularly with the Bresco case, the question has arisen in a separate context, which is whether or not it is possible for a company in liquidation to appoint or to commence an adjudication, and whether or not the responding party, as it were, is entitled to obtain an injunction to prevent them doing so. Now, the jurisdiction to grant the injunction to restrain adjudications was, of course, recognised in Twintech in 2014, albeit in a rather different context. In that particular case, the argument was that the adjudicator had not been appointed in accordance with the contractually agreed mechanism, therefore had no jurisdiction, an argument which the court accepted and said that in those circumstances, yes, it was able to grant the injunction. So that's the jurisdictional basis to grant the relief sought. Now, we then come to Bresco and Lonsdale, or as it was then, Lonsdale against Bresco, at first instance, which was 31st of July 2018. And it was tried by Mr. Justice Fraser. A fairly standard factual dispute between the parties. Both one had contracted the other to complete works, a dispute had arisen, both alleged that the other was in repudiatory breach. Bresco then entered into liquidation. Lonsdale intimated a claim against it for the cost of completing the works. Bresco alleged that Lonsdale had wrongly terminated and it had a claim for damages for completing the works and repairing the works and the like. Bresco then, the company in liquidation, gave notice of an intention to refer the dispute to adjudication. And Lonsdale brought the application before Mr. Justice Fraser for an injunction to restrain the adjudication proceeding. Now, that injunction was granted by Mr. Justice Fraser on the basis that following very much the introductory section of this talk, that immediately the liquidator was appointed, the claims and the counterclaims ceased to be capable of separate performance because of the accounting exercise that had to be carried out of all mutual claims and cross claims, which would result in only a single enforceable debt, as it were, one way or the other. And that single dispute, what was the overall balance due on the taking of the account, was a dispute that arose not under the construction contract, to which, of course, there could be reference to adjudication, but was a dispute within the liquidation, therefore fell out with the provisions of both the Act and, in that case, the contract, because it was compliant with the requirements of the Act. So the injunction there was granted. There was then an appeal to the Court of Appeal, 24th of January 2019, and both, in that case, Bresco appealed against the decision on jurisdiction. That was upheld. Sorry, bear with me, I've misread my notes completely. The appeal to the Court of Appeal, they allowed the appeal insofar as Mr. Justice Fraser had found that the adjudicator lacked jurisdiction, found that there was jurisdiction, but then went on to hold that given the fundamental incompatibility between the two regimes, the adjudication regime versus the insolvency regime, and in particular the set-off rules within it, that they would grant an injunction because, quote, the adjudication was an exercise in futility because it wouldn't be enforced in circumstances where the claimant company was in liquidation. We then move on 9 months later, and this is, it's quite strange how these matters suddenly snowball and you get the accumulation of cases. Meadowside Building against 12 to 18 Hill Street Management. This was a decision of Adam Constable, Queen's Counsel. Again, similar position. Post completion of the works, the contractor had entered into liquidation, alleged monies were outstanding, referred the matter to adjudication, and was successful on that adjudication. The defendant claimed it had a cross claim for sums due on the final account, and the claimant then brought enforcement proceedings to enforce the adjudication award in its favour. And despite being in liquidation, said the circumstances of the case were exceptional, and I'll come to those in a moment, and therefore summary judgment could be awarded. There was a consideration of the Court of Appeal's decision in Bresco, particularly its comments in the context of the futility of allowing an adjudication to proceed in where one party is insolvent, because it will not then be enforced, or generally will not be enforced. And in a very strong judgment, in fact, Adam Constable, Queen's Counsel, said that recognised that there were exceptions, and those exceptions would arise in these circumstances. So this is where summary judgment may be awarded to enforce an award in favour of a company in liquidation. The first requirement was that the adjudication brought or to be brought would determine the final net position between the parties under the relevant contract. He said, by definition, wouldn't be able to determine that net position if there was more than one contract. Importantly, to the extent the adjudication is not capable of dealing with the entirety of the mutual dealings between the parties, so that's reflecting the insolvency set-off rules. I'll start that sentence again, having interrupted it. To the extent to which the adjudication is not capable of dealing with the entirety of the mutual dealings between the parties is to be taken account of in all the circumstances when looking at the utility of the adjudication and the discretion to injunct or following adjudication to enforce. So cutting through that, if the adjudication itself is likely to mirror the accounting exercise that would be undertaken within the context of the insolvency rules, it's not futile. There's good reason for it to go ahead, and may be good reason thereafter also to enforce it, but only then on requirement too, if satisfactory safeguards can be put in place by way of the provision of security to protect the solvent company's position, both in respect of the sum awarded in the adjudication that's sought to be enforced, and in respect of adverse costs order, should they ultimately be made against the company in liquidation for an unsuccessful application to enforce, or if ultimately in subsequent litigation or arbitration, the original adjudication decision is overturned. And that security would take what you'd anticipate to be the relatively normal forms, either ring fencing of the sum in an account, third party providing the guarantee or a bond, and ATE insurance. Now, in the particular case before him, the insolvent claimant company was prepared to ring fence the monies in an account to essentially to abide the event. And the judge would have found that sufficient to enable the enforcement to be ordered in the circumstances. The difference, however, or why the application in fact failed, was because there was a funder in the background, and the funding agreement with the funder was considered to be shampitous, with the consequence that there was good argument the proceedings themselves were an abusive process. So the application was ultimately refused, but on those different grounds. We then come just a few months later, still, the beginning of 2020, to Judge Waxman's decision in Balfour Beatty against Aztec Projects Limited. Again, similar situation, company in liquidation wanting to commence adjudication, the other side, or the would-be responding party, seeking an injunction to restrain that adjudication proceeding. The slight difference in this case was that there were 3 contracts, no consent for those 3 contracts to be dealt with within the same adjudication, and therefore 3 adjudications would be necessary. Again, as he had to do, of course, the Court of Appeal having delivered its judgment in Bresco by this point in time, Mr. Justice Waxman noted the basis of the decision. There is no absolute jurisdictional bar on adjudication. It's a question about futility or not, as the case may be, given that obviously an injunction is a discretionary remedy. He then went on to refer specifically to the exceptional circumstances set out in Meadowcroft, with which he agreed. This being a case where I think a third-party guarantee had been offered to provide the necessary security. And the main battleground then distilled down to the 3 adjudications point, the argument being run that because there were 3 contracts, it was simply not possible for any single one of the adjudications to achieve that necessary effective taking of the account of all of the mutual dealings of the party. Judge Waxman didn't have a great deal of sympathy with that argument in the circumstances of that particular case, it being possible within each of the 3 proposed adjudications for the final accounts of the particular contract to be taken, as it were. And I'm using the final account word there, not in the construction terms, but in the context of the insolvency rules, the account to determine the final balance between the parties. So each of the 3 contracts, that account could effectively be taken within the adjudication. And Judge Waxman considered it obvious that any judge then on an enforcement application, even if 3 sets of enforcement applications were brought, would only give judgment reflective of the overall balance of account between the parties across all 3 contracts. And he, in those circumstances, wasn't prepared to grant the injunction sought. He also, interestingly, as we'll come back to, referred to the Stein and Blake case and basically said that the submission that made the original underlying cause of actions disappear was to take it too far, and that it was confined to its context, i.e. on the assignability of claims. So that then is the backdrop before we get to the Supreme Court. You've got the clear Court of Appeal decision, but you have then got judges of first instance, both very experienced judges in a construction field, finding ways to confine the circumstances in which the injunction might be granted, restraining adjudication. So moving away from the starting position, it's futile, to, well, it may be and probably normally is, but there can be exceptions, and these are the exceptions. We then come to the Supreme Court decision, and I'm afraid, rattle through this slightly because I think I'm probably running out of time. There was both an appeal and cross appeal. Bresco appealed the continuation of the injunction on grounds of futility. Lonsdale cross appealed and wanted to rerun its jurisdictional arguments, i.e. that there was a complete jurisdictional bar on an adjudication being commenced where the referring party was in liquidation. And again, it was essentially the same argument that was run on a liquidation. the claim and the cross-claim merge, cease to exist as independent causes of action, are replaced by the single cause of action for the remaining balance or the ultimate balance, and that is a dispute which arises not under the contract, the only disputes that can be referred to adjudication, but within the liquidation. And they sought to support that argument on the basis of don't follow the Fiona Trust line of authorities on giving words arising under or out of or in connection of a contract a wide interpretation. You should give it a narrow interpretation. This is not consensually agreed to like arbitration. This is imposed by statute. Supreme Court said nonsense. The fact it's imposed by statute actually supports a wider interpretation rather than a narrower one. It then came back, it paused the incompatibility with the insolvency set-off argument, which it dealt with then in futility. It looked at, interestingly, the single dispute rule because it was essentially a rerun of what was found at first instance, the argument that because the original claim and cross-claim merged and were replaced by a single claim, that was the single dispute, but that arose under the insolvency, not the contract. Again, that argument was rejected on the basis that it assumed that a liquidator was compelled to take enforcement proceedings in relation to the entirety of the mutual dealings between the insolvent and the creditor, which wasn't in fact the case. It was perfectly open to the liquidator to pick and choose certain issues which could be dealt with under the rules, both insolvency and court rules, in a multiplicity of ways. Echoing what Judge Waxman had said in the Balfour Beatty case, the submissions based on Stein and Blake, they said, went too far, whilst claim and cross-claim would cease to exist and merge for the purposes of assignment. That wasn't the case for other purposes, including ascertaining what the ultimate balance was when the claim and cross-claim had to be separately considered and quantified. On the futility ground, Supreme Court disagreed with the Court of Appeal. It didn't consider that there was any basic or fundamental incompatibility between the adjudication and insolvency set-off regimes. They looked to the following points in support of that. Firstly, the right to adjudicate was both contractual and statutory. Whilst an injunction would often be granted to prevent breach of contract, it would only in the most exceptional circumstances be granted to prevent somebody relying upon their contractual rights, still less their statutory rights. It made the point, which was made in the Meadowcroft case and indeed in the Balfour Beatty case, that whilst many adjudications are concerned with the cash flow position, pay now, fight later, that was not invariably the case, e.g. final account disputes, professional negligence claims and the like, and that dispute resolution was an end in and of itself, whether or not the award could then be summarily enforced, and that there was in fact greater similarities between the insolvency process and the adjudication process than there were differences. We then come probably to the more difficult parts of the judgment in some ways. Just bear with me whilst I'm just finding the paragraph. There we go. Where Lord Briggs, who gave the judgment of the court, said this: in many cases, disputed cross-claims needing to be resolved as a prelude to the final arithmetical set-off account will both or all arise under the same construction contract, as in the present case, because all of the mutual dealings between the parties will have arisen under the aegis of that single contract. Even if they arise under more than one construction contract, the adjudicator will be better placed than most liquidators to resolve them. Scheme contains provision whereby that may be achieved by consent. Need to take cross claims into account as defences by way of set off, etc. Now you'll note there that we haven't thus far touched upon, of course, all of the issues that or difficulties that you will have generally in anything bar your final account type disputes, certainly on your interim payment disputes, that you can't actually raise the cross claim because it's simply a question of whether or not the relevant notices have been served, unless you then, of course, commence a second adjudication to get a proper valuation. So that isn't considered here at all, and it's a surprising omission in the judgment. And earlier on, when he was looking at the single dispute issue, again, Lord Briggs didn't in fact touch upon in any way the limitations in bringing a cross claim by way of set off within the adjudication context in the construction field, given the provisions of section 111, etc., payment notices and the like. Overall, the determination was that adjudication was not futile, but had great utility, and that any difficulties in relation to summary assessment, summary enforcement, could be dealt with and should be dealt with at the summary judgment stage, in line with the authorities I've referred to, the Boyg against Dahl Jensen and the like. Whilst here there isn't actually any change of legal principle, there's no disagreement with the earlier authorities, there is a noted change in the tenor of the language, which again, and in line with the two Meadowcroft and Balfour Beatty decisions I referred to, is showing a softening and a movement towards enforcement on a summary basis, even within the context of liquidation, provided that there are sufficient safeguards in place. And you see that really in the language of paragraph 65. Furthermore, it will not be in every case that summary enforcement will be inappropriate. There may be no dispute about the cross-claim. The claim may be found to exist in larger amounts, such that the balance would be due, or if the cross-claim can be determined by the adjudicator because they form part of the same dispute under the contract, the adjudicator may be able to determine the net balance. And then in paragraph 67 of the judgment, the proper answer to all of these issues about enforcement is that they can be dealt with, as Lord Justice Chadwick suggested, and that's in the Boyg-Dahl Jensen case, at the enforcement stage, if there is one. In many cases, the liquidator will not seek to enforce the adjudicator's decision summarily. In others, he may offer appropriate undertakings, such as to ring-fence any enforcement proceeds. See the discussion of the undertakings in the Meadowside case. Where there remains a real risk that the summary enforcement of an adjudication decision will deprive the respondent of its right to have recourse to the company's claim as security, pro tanto for its cross-claim, then the court will be astute to refuse summary judgment. So the position now, in summary, there is no bar on adjudication within insolvency proceedings. It is highly unlikely, there may still be exceptional circumstances, but it's highly unlikely that you would be successful in obtaining an injunction if sought to restrain a company in liquidation from pursuing an adjudication. And we are back to really the starting position, which is raise your cross claims if you can't raise them by way of defence at the summary enforcement stage. The only other issue I think that really may follow on and needs to be fully played out following the decision in the Supreme Court is this, and it would be the situation where, absent the insolvency, there would be no defence. So you pay, as I said, your interim payment notice type dispute where the relevant notices or withholding notice, payless notices haven't been served. And I would certainly be interested in pushing the decision of the Supreme Court that in relation to how the insolvency rules into play, to see whether or not you could get away with saying, well, whilst the normal situation may be that these matters couldn't be taken into account by way of a cross-claim, given that the claimant company is, or referring company is insolvent, such that the insolvency rules have kicked in, you can in fact, adjudicator, even on this dispute, take into account my cross-claim, because what you are now concerned with is determining the overall balance between the two of us, rather than your pay now, litigate later analysis. That, I think, is the next door that needs to be pushed. Whether or not it can be pushed open successfully is another matter, but it's certainly one to look at. Now that's everything I had to say. Sorry, I've just seen Gary's email now at 25 minutes, Kelly, so I will shut up. Does anybody have any questions for me, or indeed either of Oliver or Jonathan if they're still on? I can't see any having come up on the Q&A. Just giving somebody a couple of moments to start typing a question. It's always the difficulty with the slight delay that you have on these remote webinars. No, I think I'm getting off scot-free, for which I'm all eternally grateful to all of you. I'd like to thank both Oliver and Jonathan for devoting their time today and for their very interesting talks. And I'd, of course, like to thank all of you as well for attending. Certainly we will, as has been confirmed, if you've been watching the chat, we will be circulating slides after the event. And if, of course, you do have any questions on reflection about any of the talks, please feel free to email them into probably Gary, who will circulate them to us all. And otherwise, I would thank you all very much for attending, and have a very nice holiday period in a month's time.